Hello class 8 students. Welcome back to the Civics class. I am your social science digital mentor. Today we are going to start chapter 6, Role of the Police and the Courts. Learning objectives, hierarchy in the police force, FIR, First Information Report. Let's warm up. Look at the following pictures. Identify these famous personalities pictured alongside. In your notebook, make a list of 5 words that come to your mind when you think of the word police. Discuss your answers. Application skills. Class 8A was meeting Sujal Bharadwaj. Sujal Bharadwaj, the inspector at the local police station. Ms. Shikha had invited him to talk to the class about the role of the police plays in a democracy. Inspector Bharadwaj told the children that he and the other policemen worked hard and to preserve law and order and put criminals behind bars. Let us see how the police and the courts together create a lawful society. Why do we need a lawful society? The police play a vital role in our society in maintaining the law and order. When we see someone violating a law, we immediately think of informing the police. The police represent the civil authority of the government. Police officers are entrusted with a variety of duties. Hierarchy in the police force. Like any other professional organization, the police force also has different ranks. The police at the state level is the of Director General of Police, DGP, the Superintendent of Police, SP, the Police Inspector, the Sub-Inspector, the Head Constable and the Constable. Everybody works together as a team to maintain law and order in our country. The police in action. 2 people were injured and several vehicles were damaged in a low-intensity blast near the famous Dagadushet Halwai Ganesh temple on 10th July 2014. According to reports, the bomb was placed in a bike which was parked in the Faraskhana police station parking lot. Police cordoned off the area and picked up 5 suspects. Top police officials and bomb detection and disposal squad reached the spot. While forensic experts scoured the area to collect evidence, according to sources, a team from Mumbai anti-terrorism squad rushed to assist an AT's team already stationed in Pune in the probe. Sources in Mumbai AT said it was too early to conclude whether the explosion was the handwork of terrorists. Based on the above news report, answer the following questions. Number 1. Which place was affected by the blast? 2. Where was the bomb placed according to the reports? 3. What are the sum of the functions performed here by the police? Functions of the police. Some important duties performed by the police are listed below. To maintain law and order in our country, to prevent crimes and control terrorist activities, to protect public properties including roads, railways, bridges, etc., against acts of violence or any kinds of attack. To create and maintain a feeling of security in the community. To maintain dignity of an individual by safeguarding his/her fundamental rights. To enforce the law impartially. To protect the weaker sections of the society. Fact file. Kiran Bedi is the first woman to join the Indian Police Service IPS in 1972. Before the colonial period, systems of administering day-to-day life were of decentralized nature. Progressively, various departments of administration emerged. Their roles were defined and guidelines were laid to systematize everything. After independence, the concept of the welfare state comes into existence, and the police were expected to perform their duties with more efficiency and a spirit of service to the people. The police are the ubiquitous organization and are found everywhere in our hour of need. We approach the police who are duty bound to safeguard us and our rights to the best of their abilities. The police protect us and ensure our safety, thus allowing us to lead our lives with the sense of security. In this picture, you can see Indian police. An important function of the police is to investigate the complaint against a crime that has been committed. An investigation includes recording statements of witnesses and collecting different kinds of evidences. On the basis of the investigation, the police form an opinion if the police think that the evidence proved the culpability of the accused. Then they file a charge sheet in the court. A charge sheet is a formal document of accusation prepared by law enforcement agencies in India. It contains information about the accused and the witnesses, the nature of accusations and specifications, and the identity of the accuser. The police can begin their investigation of a crime with the first information report or FIR. An FIR is a very important written document prepared by the police when they receive information about any cognizable offense. Cognizable offense are the cases that deal with the criminal acts like theft, murder, and rape. A police officer can arrest a person without a warrant in cases of cognizable offenses. Non-cognizable offenses are the cases which are relatively less serious in nature as compared to the cognizable offenses. Examples of non-cognizable offenses include creating a public nuisance, mischief, etc. The police cannot register criminal case or conduct arrest in case of non-cognizable offense. Arrest without a warrant. A police officer may arrest any person without an order from a magistrate and without a warrant under the given circumstances. If the individual commits any cognizable offense like murder, physical harm, kidnapping, etc. If the individual obstructs a police officer in the execution of his duty and has escaped attempts to escape from lawful custody. If a person has been declared an offender by the order of the state government or the central government. Rights of the arrested. The police are not allowed to torture or beat or shoot anyone during the investigation. They cannot inflict any form of punishment on a person even for petty offences. The Constitution of India under Article 22 guarantees the following fundamental rights to every arrested person. The person has the right to be informed about the reason for his arrest and the offense he is accused of. The person cannot be detained in custody without the permission of the magistrate beyond 24 hours of arrest. The person cannot be ill-treated or tortured during arrest or in custody. The confessions made by the arrested person in police custody cannot be used as evidence against him, her. Boys under the age of 15 years and women cannot be called to the police station only for questioning. After a person is arrested, it is the court of law that decides whether the accused person is guilty or not guilty. Our constitution gives complete liberty to every person to hire a lawyer to defend him, her against the charges. The person can also be granted bail on arrest. Bail in law means procurement of release from prison of a person awaiting trial or an appeal by the deposit of security in the form of money or property to ensure he/she will appear in the court for trial. We also have a provision for granting anticipatory bail, which is an instruction not to arrest a person on bail till he/she is named or accused of committing a non-bailable offense. FIR, First Information Report. The police do not investigate all the complaints that people put before them. If a case is not serious in nature or there aren't enough grounds for investigation, it can be ignored. Anyone can report an offense to the police either orally or in writing. Even a telephonic message can be treated as an FIR. A police officer who comes to know about a cognizable offense can file an FIR himself, herself. An FIR is a document that initiates criminal proceedings to punish the guilty. The police can register FIRs only for cognizable offenses. An FIR has to be registered at the earliest after the incident has occurred. A delay in registering the case may cause unnecessary delay in the investigation. Any such delay needs to be explained adequately. Ideally, an FIR should be registered in the police station within whose jurisdiction the crime takes place. However, in case of an emergency, any other police station may register the FIR and then eventually transfer the investigation to the concerned police station. Also, it is not always necessary to go in person to register an FIR. In an emergency, the police can register an FIR based on a phone call or an email. Contents of an FIR. An FIR contains the name and address of the complainant. There is a prescribed form in which the police record an FIR and it is signed by the complainant. The complainant also has a legal right to get free copy of the FIR from the police. An FIR also mentions the date, time, and place of the offense and details of the offense, including a description of the events. If the identities of the perpetrators and witnesses are known, then they are also mentioned in the FIR. The accused may then be arrested for committing the alleged offense. Refusal to register an FIR. An FIR can be registered either as a written statement or verbal statement of the complainant. It is later reduced in writing by the police officer and is signed by the complainant. If the complainant does not discuss any offense or discloses only a non-cognizable offense, then an FIR cannot be registered. However, if the police refuse to register an FIR, a written complaint can be sent to a higher ranking officer such as the Superintendent of Police (SP), the Deputy Inspector General (DIG), or the Inspector General of Police (IGP). A complaint may also be given directly to the judicial magistrate who can direct the police to investigate the case. One can also file online complaint on the website of the National Human Rights Commission (NHRC), that is http://nhrc.nic.in, in case of a cognizable offense and the police have refused to register an FIR. SC directives on non-registration of FIRs. The Supreme Court says that if an FIR is not registered in a timely manner, then the complainant may approach the concerned magistrates. The complainant must file a petition to give direction to the police to register the case immediately upon receipt. In case an FIR is not registered and or steps are not taken by the police, then the magistrate may initiate a contempt proceeding, the disciplinary fact file. The Supreme Court on November 10, 2013 said that it is mandatory for the police to register the first information report (FIR) if a complainant approaches them for registration of a cognizable offense. The disciplinary authority may initiate proceedings against such officers which may lead to their suspension. Case study: non-registration of FIRs. Sonali Paul, name changed on request, a 39-year-old resident of South Kolkata, commutes to Canning Road every day, where she works for a government-aided organization. In August 2010, she began to be harassed by a group of 5 men on the local train. On one occasion, she was seriously molested and very nearly fell from the moving train. Naturally, Paul went to the police to register a complaint. However, the officials at the police station near Canning Road refused to register a first information report (FIR). The South 24 Parganas Superintendent of Police also did not pay any heed to her predicament. Despite 2 written complaints, finally in December 2010, Paul was forced to move a petition under Section 156(3) of the Code of Criminal Procedure (CRPC) before the Alipur Court Magistrate in Kolkata, and it was only after a direction by the court that the police station in question was forced to register an FIR. Subsequently, one of the prime accused was also arrested. The role of the courts. The criminal justice system in our country consists of the police, the judiciary, the prosecution division, and the prison correctional departments. The police are entrusted with the job of investigating a crime and collecting enough evidence and witnesses to produce the criminal to the full extent of the law. The police submit a report to the courts, after which the courts decide whether the accused should be prosecuted or not. The state government then appoints a public prosecutor to prosecute the case in the subordinate courts or the high courts. After the investigation, charge sheets are filed in the concerned courts as per the provision of the code. Public prosecutor in the court. A public prosecutor is a law officer who conducts criminal proceeding on the behalf of the state or in the public interest. Role of an ideal public prosecutor. The public prosecutor is appointed by the state. He/she conducts prosecution on behalf of the state. He/she must present a truthful picture before the court. He/she acts in accordance with the directions from the trial judge. The public prosecutor plays a critical role in maintaining impartiality in criminal justice. It is her duty to present complete and material facts, witnesses, and evidences before the court to enable the court to reach a conclusion. The public prosecutor's duties begin after the police file the charge sheet. He/she may assist in the investigative processes by obtaining necessary warrants. The prosecutor is also required to assist the court in arriving at a judicious sentencing of the accused by arguing with the defense. Eligibility. A person to be appointed as a public prosecutor or assistant public prosecutor should have been in practice as an advocate for at least 7 years. For appointment of a special public prosecutor, a person must have been in practice as an advocate for at least 10 years. If one fulfills the eligibility criteria, then she is appointed with the concurrent of the Chief Justice of the High Court. Judges in the court. The judges hears all the witnesses and is presented with all the evidences by the prosecution and the defense. On the basis of the law and the court trial, the judges then decides whether the accused is guilty or innocent. If the accused is guilty, then the judge pronounces the sentence. He may send the person to jail or impose a fine or both, depending on the case. Understanding our criminal justice system. After a person is arrested, it is the court of law that decides whether the accused person is guilty or not. According to the Constitution, every individual charged of a crime has to be given a fair trial. A fair trial is ensured by Article 21 of the Constitution, Protection of Life and Personal Liberty, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This means that every citizen, irrespective of his, her class, caste, gender, and religious or ideological background, gets a fair trial when accused of some wrongdoing. A fair trial gives the accused the right to defend himself, herself in the court. If the accused is not in condition to afford a lawyer, then the state provides a lawyer for him, her at its own expense. Article 39A. The judges need to remain impartial and decide cases on the basis of the evidences submitted in the court. Value and life skills. The principal role of the judiciary is to protect rule of law and ensure supremacy of the law. It safeguards rights of the individual, settles dispute in accordance with the law, and ensures that democracy does not give way to individual or group dictatorship. Recapitulation. The police help to maintain law and order of the country, safeguard our fundamental rights, and also protect the weaker sections. Like any other profession, the police force also has a hierarchy. One important function of the police is to investigate a complaint about a crime. The police can begin its investigation of a crime with an FIR, First Information Report. There are two types of offences, cognizable offences and non-cognizable offences. After a person is arrested, it is the court of law that decides whether the accused person is guilty or not guilty. If you are reporting a cognizable crime and the police refuse to register your FIR, you can complain against him to a higher ranking officer. Thank you class. Let's meet again in the next chapter.